If you obtained U.S. citizenship through naturalization, and recently you found yourself staying awake at night wondering, can this be reversed? You're not the only one. You observe the headlines, you observe the enforcement coverage, you hear the terms crackdown, deportation, immigration reform, and suddenly something that once seemed permanent starts to seem uncertain. You work toward this. You prepared for the civics examination, you succeeded in the interview, you stood in a courtroom and took the pledge. You believe that moment represented safety, completion, security. So when immigration policy fills the news in February 2026, it's understandable to ask, has anything shifted about my citizenship? Is naturalized citizenship truly protected? Could enforcement policies somehow affect me? Today, we're going to distinguish concern from reality, headlines from legislation, and speculation from constitutional truth. Because there's a significant difference between a more vocal enforcement environment and an actual legal threat to your citizenship, and comprehending that difference transforms everything. Hello, I'm Sophia, and welcome to US Updates. My work is centered on explaining immigration policy clearly, calmly, and factually, especially during moments like this when concern spreads faster than reliable information. In this video, we're going to examine step by step through what Trump immigration policy in February 2026 actually represents for naturalized citizens, what the Constitution ensures, what denaturalization truly is, and what it is not, and the practical steps you should or shouldn't consider right now. This is not about politics, it's about legislation, rights, and clarity. By the conclusion of this, you'll know exactly where you stand, what is safeguarded, and what you can confidently stop worrying about. And that clarity matters more than ever. Let's begin with the foundation, because once you comprehend this clearly, much of the concern begins to disappear. Under the United States Constitution, citizenship once lawfully provided is permanent. That's not a political statement. That's not dependent on who is president. That is constitutional legislation backed by Supreme Court precedent going back many years. If you completed the naturalization procedure, met the residency requirements, succeeded in your civics and English examinations, disclosed the required information, and took the Pledge of Allegiance, you are a United States citizen with the same constitutional safeguards as someone born in this country. Your citizenship is not a visa. It is not a green card. It is not conditional status. It does not renew. It does not terminate. And it cannot be removed simply because immigration enforcement becomes more assertive or political leadership shifts priorities. Executive orders cannot override constitutional safeguards. Shifts in enforcement approach cannot rewrite the 14th Amendment. Congress cannot pass a simple legislation that suddenly removes lawfully naturalized citizens of their status. Citizenship, once properly provided, is not uncertain. It is one of the strongest legal statuses that exists in American legislation. Now, I want to pause here for a moment because this is important. Many people subconsciously transfer the concern they experienced as permanent residents into their life as citizens. As a green card holder, your status could be questioned under certain circumstances. There were conditions, there were risks, there were renewal requirements and travel limitations. Citizenship is different. It is final. It is a constitutional status, not an administrative one. And if this kind of clear, fact-based explanation is helpful to you, make sure you're subscribed to this channel so you don't have to depend on rumors or social media discussions the next time immigration fills the headlines. Reliable information is one of the most powerful forms of security you have. But, and this is where we need to be precise, there is one narrow legal exception that people often hear about without fully comprehending it. It's called denaturalization, and this term alone causes alarm because it sounds like the government can simply reverse citizenship. That's not what it represents. Denaturalization is a formal legal procedure that can only happen in federal court and only under very specific circumstances. The government must demonstrate that a person obtained citizenship through fraud or by willfully hiding a material fact during the naturalization procedure. This is not about policy disagreements. It's not about shifting political parties. It's not about criticizing the government. It is about whether the original naturalization was legally valid. To meet that standard, prosecutors would have to present evidence that someone deliberately misrepresented on their N-400 application, concealed serious criminal history that would have made them ineligible, used a false identity, concealed involvement in persecution or wrongdoing, or omitted information that was legally material to the approval determination. And even then, it is not automatic. The government must file a civil lawsuit. The individual has the right to legal representation. There is discovery. There are evidentiary standards. There is a judge. The burden of proof is high. And historically, denaturalization cases are rare, time-consuming, and expensive. They are not mass administrative actions. They are individualized court proceedings that often take years to resolve. This distinction matters enormously in 2026 because when people hear about stronger immigration enforcement, some assume that citizenship could somehow be included into that enforcement movement. But denaturalization is not a policy instrument that can be expanded casually. The legal standard has not shifted. There has been no new legislation changing the burden of proof. There has been no Supreme Court ruling weakening constitutional safeguards for naturalized citizens. Even if an administration wanted to pursue denaturalization cases more forcefully in cases of proven fraud, it would still be bound by the same constitutional requirements and due process safeguards that have existed for many years. So when you hear the phrase removing citizenship, comprehend that in reality, it refers to a narrow court-driven procedure tied to fraud, not a political mechanism that can be applied against law-abiding naturalized Americans. So, if naturalized citizenship is constitutionally safeguarded and denaturalization is rare and fraud-based, what exactly is occurring right now in February 2026 that's making so many people uneasy? The answer is enforcement visibility. The current administration has significantly increased immigration enforcement operations. ICE activity is more frequent and more public. Detention policies are stricter. Border enforcement has intensified. Deportation efforts are being prioritized for individuals who are undocumented or who have final removal orders. That shift in visibility transforms how communities perceive, even if it doesn't transform the legal reality for citizens. When you observe workplace operations covered on the news, when you hear about large-scale removal operations, when social media amplifies every enforcement story, it creates the impression that the entire immigration landscape is unstable. But here's the critical distinction. Enforcement actions target immigration status violations. Naturalized citizens do not have an immigration status. You have citizenship. You are not in the category of people subject to deportation proceedings. You do not need a visa. You do not need to renew anything. Your legal relationship with the United States is fundamentally different from someone who is undocumented or even someone who is a permanent resident. This is where confusion spreads. Immigration policy debates often get framed broadly. Crackdown on immigrants, strict immigration reform, new deportation initiative, but those phrases collapse multiple legal categories into one emotional headline. A green card holder is not the same as an undocumented immigrant. A visa holder is not the same as a naturalized citizen. Enforcement aimed at unlawful presence does not legally extend to people who have completed naturalization. Yet, when language becomes intense, people who spent years navigating a vulnerable immigration system can instinctively perceive like that vulnerability has returned. It hasn't. The approach may be harsher, the enforcement may be more visible, but approach is not legislation. Visibility is not a constitutional amendment, and intensity does not rewrite citizenship safeguards. Now let's address 3 of the most common claims circulating right now, because misinformation thrives in environments like this. The first claim is that mass denaturalization is approaching, that the government is preparing to remove citizenship from large numbers of naturalized Americans. There is no legal mechanism for this. There is no new legislation authorizing it. There has been no constitutional shift allowing it. Denaturalization, as we discussed, requires individualized federal court proceedings tied to fraud. It cannot be executed in bulk through administrative action. The second claim is that certain nationalities or religious groups are being targeted for citizenship removal. While immigration enforcement priorities can focus on particular geographic regions or security concerns, denaturalization cases must be based on fraud or material misrepresentation, not race, religion, ethnicity, or political belief. Targeting citizenship removal based on those characteristics would be unconstitutional and immediately challenged in federal court. The third claim is that naturalized citizens need to take urgent, dramatic steps to safeguard their citizenship. Renouncing prior citizenship immediately, filing special paperwork, paying for security services, or registering with organizations promising safeguards. None of that is necessary. Your citizenship is safeguarded by the Constitution, not by additional filings or private services. Concern-based businesses often emerge during times of uncertainty. Be cautious of anyone asking you to pay money to protect something that is already legally protected. Comprehending what is actually occurring and what is not transforms how you respond. There is a real enforcement shift in 2026. There is a heightened focus on undocumented status. There is political intensity around immigration, but none of those developments alter the constitutional permanence of lawfully obtained naturalized citizenship. When you separate enforcement appearance from legal authority, the picture becomes much clearer and much less concerning. Now that we've separated legal reality from political noise, let's shift into something practical. Not because your citizenship is in danger, but because clarity becomes even more powerful when you know what to do next. The first step is simple. Safeguard your documentation. Keep your naturalization certificate in a secure location. Make physical copies, and if possible, secure digital scans stored safely. This is not because someone is approaching to question your citizenship at random. It's because having immediate access to proof eliminates worry if you ever need to apply for a passport, replace documents, sponsor a family member, or verify your status for any reason. Organization reduces concern. The second step is comprehending your rights as a citizen. You have full constitutional safeguards. You have the right to due process. You cannot be deported. You can travel on a U.S. passport. You can vote. You can petition for family members. These rights are not symbolic. They are enforceable. Sometimes simply reviewing what citizenship legally grants you restores a sense of stability that headlines can temporarily disturb. Third, if you have family members who are lawful permanent residents and eligible for naturalization, this is an important moment to consider encouraging them to apply. Permanent residence is strong, but it is not the same as citizenship. Green card holders can still be placed into removal proceedings under certain circumstances. They must maintain residency requirements. They are subject to immigration enforcement regulations in ways citizens are not. Naturalization provides completion. The procedure itself has not fundamentally shifted in 2026. It still requires physical presence, continuous residence, English proficiency, civics knowledge, and good moral character. But if someone in your family qualifies, pursuing citizenship can provide long-term security that is particularly meaningful in an enforcement-heavy climate. If this explanation is helping you think more clearly about your situation or your family's options, consider sharing this video with someone who might be quietly worried but hasn't asked these questions out loud. Sometimes clarity spreads one conversation at a time. Now, let's discuss more complicated family scenarios, because this is often where concern really exists. If you have undocumented relatives, the current environment is not favorable for ignoring that reality. Enforcement is active, deportations are occurring, undocumented status carries real vulnerability, and hoping that visibility will diminish is not a strategy. That doesn't mean alarm, it means consultation. There may be pathways someone hasn't explored. Adjustment through family, humanitarian safeguards, waivers, cancellation of removal, or other relief depending on the facts. But those options are case-specific and require a licensed immigration attorney to evaluate properly. Guesswork and internet advice are dangerous in this climate. If you are sponsoring a relative abroad, comprehend that family-based immigration remains legal, but processing times may lengthen, scrutiny may increase, and policy adjustments could affect categories or numerical caps. Delaying unnecessarily can sometimes mean facing stricter standards later. And if you travel internationally as a naturalized citizen, always travel on your U.S. passport. The United States recognizes dual citizenship, but some countries do not. If you return to your country of origin, be aware of that country's regulations regarding dual nationality, taxation, or military obligations. None of those issues affect your U.S. citizenship, but they are practical realities worth comprehending before you travel. What all of this comes down to is this: your citizenship itself is stable, but your family's immigration situations may still require attention. Stability at the top of the ladder does not automatically protect every step beneath it. Being proactive, not concerned, but proactive, is the most constructive response to a high enforcement environment. At this point, you might be asking a very practical question: do I need an immigration attorney right now? And for most naturalized citizens with straightforward histories, the answer is no. If you obtained your citizenship lawfully, disclosed required information honestly and have not been contacted by the government regarding fraud or misrepresentation, there is no preventive legal filing you need to make. There is no special protective step required. Citizenship does not need maintenance. It does not need renewal. It does not require defensive paperwork. However, there are specific situations where consulting an immigration attorney makes sense. If you are sponsoring a family member and the case involves prior overstays, removal orders, criminal history, or complex waivers, you absolutely want professional guidance. If you have undocumented relatives trying to assess their options, that evaluation must be individualized. If you ever receive formal communication from USCIS, the Department of Justice, or any federal agency questioning past immigration representations, that is the moment to seek counsel immediately. And when I say attorney, I mean a licensed immigration lawyer, someone admitted to practice legislation, ideally focused specifically on immigration matters, and preferably connected to reputable organizations such as the American Immigration Lawyers Association. Be cautious of anyone who guarantees outcomes. Be cautious of large cash demands without written agreements. Be cautious of notaries or consultants presenting themselves as attorneys when they are not licensed to practice legislation. Immigration fraud increases in periods of uncertainty because concern creates opportunity. A real attorney will evaluate your facts, explain risks clearly, and never promise impossible results. They will not tell you they can safeguard already protected citizenship for a fee. They will not invent emergency filings that do not exist. Legal guidance should reduce concern, not exploit it. Now I want to shift to something that doesn't appear in statutes or court rulings, but is very real. Emotional residue. Many naturalized citizens carry years, sometimes many years of immigration-related worry. You may remember what it felt like to wait for visa approvals, to check case statuses online obsessively, to worry about missing a document, to perceive that a mistake could derail everything. That psychological imprint doesn't disappear overnight just because you received a certificate of naturalization. So, when enforcement headlines surge, even if your logical mind comprehends that your citizenship is protected, your nervous system may react differently. You might perceive a flash of the old vulnerability. You might question something that is legally settled. That reaction doesn't mean you misunderstand the legislation. It means you lived through uncertainty for a long time. It's important to give yourself credit for that journey. You navigated a complex legal system. You met the requirements. You earned citizenship lawfully. The concern you once experienced was rational in earlier stages of your immigration procedure, but the legal landscape of your status has shifted. You are no longer in a provisional category. If you find that the current political climate reactivates old concerns despite knowing the legal facts, consider leaning into community. Discuss with other naturalized citizens who share similar experiences. Connect with immigrant advocacy organizations that provide reliable updates. If worry perceives overwhelming, there is no weakness in seeking counseling support to process it. Security is not only a legal condition, and it's also a psychological one, and both matter. As we examine at the bigger picture in February 2026, it's important to separate two forces that often get blended together: political climate and constitutional structure. Political climate can shift quickly, enforcement priorities can intensify, public language can become sharper, media coverage can amplify every action, but constitutional structure moves slowly, deliberately, and with high barriers to shift. Citizenship falls into that structural category. It is anchored in the 14th Amendment and reinforced by many years of Supreme Court precedent. That foundation does not move with each election cycle. So when you hear sweeping language about immigration crackdowns, remember that those policies operate within legal categories: undocumented status, visa violations, removal orders, asylum eligibility. Citizenship is a different category entirely. If you naturalize lawfully and honestly, there is no hidden mechanism waiting to reverse that. There is no executive shortcut. There is no quiet administrative sweep. There is no new 2026 statute that has rewritten the regulations of denaturalization. The legal standard remains fraud or willful concealment of material fact proven in federal court with full due process safeguards. Here's what we know clearly. Immigration enforcement in 2026 is visible and active. Deportations of undocumented individuals are occurring. Border and detention policies have tightened. Policy debates around asylum, work visas, and family-based immigration continue. But none of those developments alter the permanence of lawfully obtained naturalized citizenship. If you answered your application truthfully, disclosed what you were required to disclose, met eligibility requirements, and took the pledge, your citizenship is protected under the Constitution. That is not optimism, it is legal fact. So the path forward is not alarm, it is awareness. Stay informed through reliable sources like USCIS, the State Department, reputable legal organizations, and licensed immigration attorneys. Keep your documents organized, encourage eligible family members to naturalize, seek professional advice when cases are complex. And most importantly, allow yourself to exist in the stability you earned. You have the right to vote. You have the right to hold a U.S. passport. You have the right to petition for family members. You have the right to exist here without concern of deportation. Those rights are not symbolic. They are enforceable constitutional safeguards, and comprehending them fully is one of the strongest responses to a noisy political environment. If this video has helped you perceive clearer about what naturalized citizenship actually safeguards and what it does not, make sure you subscribe to US Updates. We're committed to fact-based immigration guidance that cuts through misinformation and focuses on what the legislation actually states. Share this video with someone who might be worried but hasn't had access to reliable information. And if there's a specific claim you've heard or a topic you want us to address next, leave it in the comments. Your questions help shape future videos that serve real concerns in our community. Thank you for being here, and thank you for being part of a space where reliable information is treated as security, not politics.